Thank you, Gary. So the floor is yours.
Thank you so much, Hugo. And as a reminder, Hugo, I have a couple of my colleagues who are Brian Kraus and Scott Hoster, who are in our litigation group. So if they can either turn their microphones on so that they can opine when necessary, that would be great. So Hugo and I were speaking the other day. Hugo?
What's the question again?
I'm sorry. I'm getting a lot of static on my computer. Is that coming from me?
I believe so. Okay, so we can hear you, Gary. Okay. No, now we don't hear you.
Okay, how about now?
Now, perfect. Okay. Go for it.
I turned my microphone off because I was hearing a lot of feedback. Okay, let's take this from the top. I know it's we're 10 minutes late. Okay. So Hugo and I were talking the other day about some of the things that are common pitfalls for real estate investors and some things that oftentimes we don't think about, because when we start getting involved in real estate investing, we think about sourcing properties, we think about disposition of assets, we think about title insurance, but the area where investors lose consistently is on the rehab and on dealing with contractors. So if there's one thing that you can all think about, one thing such that if you do it, everything else will be easier or unnecessary, that really would be dealing with a concise contract scope of work. So oftentimes, we do 1,500 real estate closings at Castle Law a year, and I would say consistently 3-4 times a month we'll have owners who end up in disputes at the end of a project with a contractor. And more often than not, guys, it's not because the contractor is inherently a bad person. It's not because the contractor is inherently a crook. It's not because the owner is trying to beat the contractor out of money, but rather what tends to end up happening is there was never a meeting of minds between the parties. In other words, we've all seen contracts that say rehab house, $40,000. Now, if you have to think about it, what are the chances that when you have a contract that says rehab house, $40,000, that at the end of that project, you're going to have the vision that the owner had and the vision that the contractor had have a meeting of the minds? It doesn't happen. So what we have to do is we have to have a very clearly defined scope of work. And I mean very, very detailed, down to the type of carpet to be used or allowances for carpet. In other words, a certain amount of cost associated with carpet that an owner can spend. That contract has to provide for attorney's fees. It has to provide for change orders. If anybody knows anything about change orders, oftentimes when we get into a project, we're going to start tearing down walls. Maybe you as the owner have something that you want to change. If it's not written down, guys, it doesn't exist. So in order to avoid all of the calamity associated with disputes at the end, you need to have a clearly defined contract that sets forth with specificity every single item that's going to be included in the rehab, the budget for that item, when it's going to be paid. So That's really, there's no mystery behind that. Brian Scott, with regard to contracts, what do you see in court? I don't know, Scott may not know how to turn on his microphone, but Brian, what do you see in court where there's the common problems that occur where contractors and owners are suing each other?
That's a good question. Gary, is that my computer making the noise?
Go ahead.
If I apologize. I can everyone hear me clearly?
I think your computer might be the one making the noise.
Is it mine?
Yeah.
Huh. Okay. Because I'm using my computer's microphone.
Okay. Well, go ahead. We can hear you now.
Better now?
Go ahead.
Okay. I apologize to anybody who's having to listen to all the static. No, Gary, I think you stole my thunder a little bit. You described it exactly what I run into. The vision that the homeowner has is completely different than the vision that the contractor has. And a lot of times there's not a meeting of the minds, and a lot of times there's not a lot of good stuff in writing. Here's another thing I run into, and I don't want to take you down a rabbit trail, but one issue that I run into is I have landlords of commercial spaces who they don't really check up on the property a lot. The tenant goes and orders some work, and before they know it, they're hit with mechanics liens notice. So those are some issues that I run into.
Great. And so let's just talk a little bit about some of the different things that we want to be aware of when we're doing these construction loans. So I don't know how many people are aware, but when you're giving out payouts, you have to obtain waivers from the contractor. And what people sometimes don't realize is if you hire a general contractor, but that general contractor has subcontractors, you as the owner are responsible. If you pay that general contractor $40,000, but he hired an electrician, he hired a plumber, and it wasn't his own employees, if the general contractor doesn't pay the electrician, doesn't pay the plumber, doesn't pay the HVAC contractor, those subcontractors, if you as the owner have not collected those lien waivers, you as the owner will be responsible for paying the subcontractor. And a lien filed by a subcontractor that wasn't paid, even though you paid the general contractor, will be a valid lien. So yes, what I'm saying is you will pay twice. Now, how do we avoid that? Well, one of the things that you can do, and many people who are affiliated with Chicago REIA, and many investors are doing private money loans. And these private money lenders and their attorneys are not requiring a construction escrow, and they're not requiring a title company to collect lien waivers. Well, that places a tremendous amount of exposure on both the lender and the owner, because if you hire a title company to handle all of the construction draws, the title company will make sure that the proper sworn statements, lien waivers are collected by the general contractor and all subcontractors before they are paid. And believe it or not, the cost to have a construction escrow opened at a title company is very, very minimal. I mean, you may be talking about $500 or $600 for the total project for them examining all of these lien waivers. And for those people who have been involved in disputes and have to pay attorneys, that's a small amount to pay to minimize your risk and as well as maximize your return. And remember, when we're talking about real estate investing, what we want to do is we want to minimize our risk and maximize the return. So one of the things that you can do, one of the key things that would make everything else easier or unnecessary, is as an owner, whether you're paying cash or whether you have a private money loan where your lender is not requiring construction draws, is to establish that escrow with the title company. So we want a clearly defined contract, a clearly defined scope, a contract that provides for attorney's fees if you have to file an action against them. And it sets forth all the obligations and responsibilities of the party. So we need to include everything that is required to complete the job. All items. Are they going to go and get the permits? Are they responsible for paying for the permits? Who's responsible for the final village inspection? Who's responsible for all of the performance milestones? Are there architectural plans that need to be provided? Who's responsible for engaging the architect or engineer? And again, we have to make sure that that document is a legally enforceable contract, because there is no final contract unless it is fully executed by the parties. So what do I mean by that? If a builder says, here's my scope, and you say go, but you haven't executed a document, both parties haven't put their name on the bottom of it. There can be oral contracts, but we want to have everything in writing. So we want to know who's responsible for those plans, what specific subcontractors are going to be utilized, when are payments to be made, does the contractor have insurance, do they have bonds, what type of insurance is necessary, the amount of insurance, what bond is required to be placed at the municipality, and providing you proof of that insurance, and the payout procedures. You know, I'm covering a lot of things with you, but we need to think about that. At what point are we going to pay? Are there going to be bonuses for finishing on time? Are there going to be penalties for finish late? Who and how is the payment to be made? What's the standard of performance that's going to take place on this project? What are the provisions for inspecting? What are the holdbacks if they haven't completed the job? So what's the time for performance? What's the schedule for work? So we at Castle Law have contracts that you can use that encompass all of this. We need to make sure that each contractor that they're going to use is properly permitted, that they're properly licensed. We need to have warranties. Are they going to provide a warranty for a year? Is that warranty extend to the party by which we're going to sell the property? Because some builders, they give you the warranty, but that warranty doesn't necessarily extend to the person who you're selling the property to. Or in case of a buy and hold, you know, you need to know what warranties you have. Are they going to indemnify you for anything that they do wrong? So these are all things that need to happen. We need to have provisions for how work orders are done and change orders. Who can give the direction for change orders? Because oftentimes you'll walk into a house and you'll say, gee, you know, I want to move this wall, move that wall. Make sure that you have a change order, because you may say, gee, that's a $500 job, but the contractor may think it's a $5,000 job. And we have to have provisions in our contracts that provide for what happens when there's a dispute. So dispute resolution provisions, and whether it's going to go to arbitration or whether it's going to go to court. What happens when there is a dispute? Do parties get to collect attorney's fees? Who's responsible for chargebacks or deductions? So if you have to complete something, are they charged back for that? So these are all things that are extremely important to be considering. Who has access to the property? You want to know all the people that are coming on your job site, that they're properly insured, because if someone gets injured, you could possibly be sued. So these sorts of things can all be extremely important in minimizing your risk and maximizing your return on your investment. Now, I've been bloviating for a little while. I want Scott and Brian to jump in here on some things that I probably missed. We're going to get into some mechanic lien issues. If anybody's had any contractors threaten mechanics liens, I'm going to give you a few techniques on how we can invalidate erroneous or fraudulent mechanics liens. I'm going to describe to you what constitutes a breach of contract, how you terminate a contract properly with owners. So before I get into liens and how to file liens and how to avoid a contractor claim for liens, Brian, Scott, do you have anything to add?
Yeah, Gary, real quick, and in a minute I'll get out of the way and let Scott talk, but so that you went over about escrow, for instance, insurance, for instance, what I would recommend, and I like to talk a lot about the landlord-tenant this, if you're a landlord, you want to get these things in a lease because especially if you've got a commercial tenant, because one of the things you're more likely to be able to defend yourself if a tenant goes out and incurs a mechanics lien for any work that tenant might do. You are more likely to defend yourself and get out of liability for that lien if you've laid out some of the things that you talked about. The escrow thing is big. I've seen a lot of leases where there's a provision where when any work done, you have to do escrow, to make sure you cover any potential problems with contractors or subcontractors, and insurance requirements, everything else. So what I would say is everything Gary just talked about a minute ago, especially if you've maybe not always appropriate for commercial tenancy, but if you're the landlord of a commercial space, you want to have your mechanics lien section at least.
Yeah, Gary bought me a nice new iPad, and I think I disabled the camera on this. Can you hear me, or?
We can hear you, Scott.
Okay. I was just going to add a couple of things. Gary mentioned change orders. That is probably one of the biggest issues in litigation come to change orders, because when you're remodeling a home, very frequently as the contractor gets in and starts looking at things, it can become a bigger, more complicated job than he or she anticipated. And so you definitely want to have in your written contract, and Gary and our firm does a lot of those contracts, you want to have a provision calling for written change orders, because there's a lot of litigation over he said, she said. You need, I didn't think you were going to put that in, and then the contractor says, well, I had to add it. We were working, and I didn't have a choice. I had to do the extra work, so you owe me an extra $3,000. That happens all the time. So you do want to have a provision in your written contract calling for written change orders that both parties sign with an agreed upon price. And the other thing is, that comes to my mind before Gary comes back into this, one of the key issues in mechanics lien law deals with the date of completion. And if you're an owner, you need to be a hands-on person on your job, because a general contractor has to record a lien within 4 months of the date that he or she last worked on the job. And a subcontractor has to record a lien within 4 months after the last date of work that he or she worked on the job. And a subcontractor also has to send out a notice, a certain kind of notice, within 90 days after he or she worked on the job. The key issue in the last day of work is it has to be substantive work. From time to time, you'll see a plumber finish, realize them that they haven't gotten paid by the general contractor. The plumber's the sub, the general hasn't paid them. They realize they've blown their 90 days, so they come back on the job site and try to readjust a faucet. The last day of work is very important, but it's the last day of substantive work. You can't extend your time as a contractor to file a mechanics lien by coming back on the job and putting a little clock on a window or something. So if you're an owner, you want to be very involved on your job site, take pictures, take notes, keep a construction log if you can, because the date of completion is very, very important in mechanics liens. And so those are a couple things I've noticed in litigating these cases for 35 years, and we'll send it back to Gary here to pick up.
Thanks so much, Scott. And guys, Scott has litigated mechanics liens. He's gone to the appellate court. Have you gone to the Supreme Court with mechanic lien cases, Scott? Oh, Scott turned his microphone off. I think he might have been to the Supreme Court with mechanic lien cases at all. And what Scott points out is it's extremely important. Scott's the head of our litigation at Castle Law, the importance of adequate records. So some of this stuff, we as lawyers, our clients tell us, gee, in a perfect world, we would do everything the lawyers say. So I understand that some of the stuff isn't practical, but really your records should show on a daily basis, if possible, the identity of the workers, the amount of time spent, the work performed, the material used, because these title companies now, for those who have been doing flips, they've gotten burned so much on these liens that they've paid out title claims, because title insurance, for those people that don't know, the title company's issuing an owner's policy to a buyer saying that it's free and clear of any liens. So if they know that there's new construction on a premise, now new construction means rehab. It doesn't mean ground up necessarily. New construction can mean a rehab. They're gonna require and demand copies of the general contractor's statement, the owner's sworn statement, and all the subcontractors, and material lien waivers. So a waiver for any and all materials placed on the site. So this is incredibly important. And if you run this through a title company, you've basically insulated yourself from liability, because they're going to collect all of this stuff that you're going to need anyway when we go to sell that, if this happens to be a property that you're flipping. So a couple of other things that I want to address with people, and by the way, we have a chat box on the side, so please place any questions that you have for Brian. Brian is the head of our litigation group at Castle Law and has his own firm that's kind of working with ours. And Scott is the head of our litigation group, and of course I am the head of real estate. But we want to make sure that when we're paying out any of our contractors, that we require and obtain a sworn statement from the contractor of how much they've paid, who they've paid, listing all of the subcontractors on that sworn statement. We can't just rely on the general contractor's statement. If you know that they have a plumber, or if you know they have an electrician, you need to require them to give you a release of lien and statement from that subcontractor, because again, guys, if you don't, the general contractor at some point, if you do this enough, because what we know about contractors, I mean, it's wonderful that contractors exist, because now lawyers aren't the lowest on the totem pole in terms of reputation. It's now contractors. But at some point, contractors, they borrow Peter to pay Paul a lot of times. So what happens is at some point that catches up. They don't pay their subs because they need the money on the next project. And if that subcontractor files a lien before you're closing, you can jump up and down, you can scream and shout, but you will have paid your general contractor, and then you will be required to pay the subcontractor again. And then you're going to be forced to chase the general contractor for the money. So key in business, in any business, whether it's real estate or anything, is we want to minimize our risk and maximize our return. So we're minimizing our risk by ensuring that the payment that we make, everybody has been properly paid. Now, what happens if someone files a lien and that lien is erroneous? That lien is unfair. Maybe it's the wrong amount. Maybe there's just a general dispute between yourself and the lien claimant. Lien claimant will call the contractor. What happens then? Well, many lawyers, or most lawyers, don't actually know this, especially real estate lawyers. We get to the title company and it shows up on the title, and the owner feels like they have their hands tied behind their back, and the general contractor thinks that they have you held hostage. Well, there's several things that we can do to defeat a lien claim that has been filed fraudulently or erroneously. First and foremost, we need to determine whether the lien was properly filed on time, whether the proper people were served with a notice, and we can file what's, and I'm going to have Scott jump in here because I start to you know, get off kilter, but I think it's called Section 34 of the Mechanics Lien Act. We can actually serve the general contractor with what's called a Section 34 notice. I like to call it the shit or get off the pot notice. And what that says is that they are required to file a foreclosure on their mechanics lien within 30 days of service of that notice. And if they fail to file a foreclosure of the mechanics lien within 30 days, the lien is automatically invalidated. Scott, put your microphone on. Do I have it right so far?
Yeah, that's absolutely right. Sometimes contractors file liens just to try to extort some money out of an owner of some property. And so Section 34 allows an owner to push a contractor and force the contractor to file a mechanics lien foreclosure suit within 30 days of the date the owner serves the contractor with that notice. And if they don't file a lawsuit to foreclose their lien within 30 days, then the mechanics lien is forfeited, and the owner can get rid of the lien using that technique. So that's, Gary's description was totally correct, yes.
And guys, let's further elaborate on that point, because one might say, well, gee, you know, I signed the contract and my closing's in 30 days. You know, maybe the time period hasn't run by then. Well, we're going to deal with the title company on that because we're the largest real estate investor law firm for investors in the Midwest. We have relationships with the title companies where we can allow these closings to occur. You can close, you can get your proceeds, and we can clean this up after the fact. Depending upon the amount of the lien, sometimes they're going to require a little bit of a holdback. You know, maybe the total cost of the lien, sometimes 1.5 times. Sometimes, depending upon the situation, I can avoid an escrow at all. So let's say, to real life example, plumber files a lien for $5,000. on day 1, your closing's in day 25. We send that section 34 notice, but the 30 days hasn't run. If we can prove to the title company that we sent the notice, we give them the green card showing them we've sent the notice, proof of mailing's enough, you don't have to have the green card returned, then they're going to allow us to close on that, maybe with a personal undertaking from you, which is a guarantee, maybe with bonding over by putting a certain amount of money up. But once that time period expires, they're going to release those funds back to you. Now, here's the other beauty of this. The mechanics lien, section 34 of the mechanic lien statute provides that in the event that a person fails to file the foreclosure of the mechanics lien within that 30-day period, and thereafter, upon demand, does not provide you with a release of that mechanics lien, you are entitled to your attorney's fees to have that lien removed, as well as statutory damages. Scott, what's the statutory damage amount?
Well, it's woefully cheap. It's hardly, I think it's about $100, which is unfortunate because the legislature hasn't really changed it in the past 50 years. But you can get your attorney's fees so you're made whole. But unfortunately, the statutory penalty is not very much.
Okay, all right, fine. But you can get your attorney's fees back for actually having that lien removed. And my experience, and again, we send the title companies a huge volume of business. So as investors, one of the keys is that you need to be able to have leverage in your business. We provide that leverage for you because we have the leverage with the title companies, because I send them millions of dollars worth of business a year. So they're going to take certain risk. They're not going to jump off a cliff for me, but they're going to take a certain amount of risk because they know if I say I'm going to do something, I'm going to do it. So they'll allow us to close these, and they will insure over that mechanics lien. And once they've insured over that mechanics lien and they know the 30 days expire, it's void by operation of law. Now, again, there's time frames associated with liens too. Liens are only valid for a certain period of time. For those of you, and I know a lot of you are, buy and hold people. If you're a buy and hold person and the contractor's threatening with filing a liens, I don't want you to laugh in their face, but really the lien is somewhat of a kind of a paper tiger, because if you're not selling that property anytime soon, a lien is only valid from the date in which it's filed. Scott, is it 1 or 2 years?
The statute of limitations is 2 years from the date that they completed the work. So if they don't file a lawsuit to foreclose their mechanics lien within 2 years after their last date of work, they've blown the statute of limitations and their lien is no good.
Okay. And Scott, if you could just on a 10,000 foot level, somebody files a lien, what are we talking about when we say that in order to collect their money, they have to foreclose on their lien?
Well, that means that they have to file a lawsuit in the circuit court, just like a bank does. When a bank goes to foreclose a mortgage, it is the same type of lawsuit. It's called a mechanics lien foreclosure. And it is a lawsuit filed in the circuit court saying, I filed a lien on this property and the owner of this property owes me a certain amount of money. It's similar to a mortgage foreclosure where a lender says the owner owes me a certain amount of money. So it's a lawsuit. It takes anywhere from 1 to 2 to 3 years to get for a mechanics lien claimant to get their case through the system. And so again, the owner has some leverage to try to settle if they dispute the lien. And it is a lot of work to file a mechanics lien. So contractors sometimes make threats, but a lot of the time their threats are empty.
And Scott, I know my clients have to listen to me preach about, preparing these contracts and get everything in order and minimizing their risk and maximizing their return and the importance of that. What's the cost on average for a lawsuit when there's one of these contractor disputes, or what can people count on paying?
Well, it depends on the size of the matter. I mean, I'm representing a contractor on a $350,000 lien on the promenade in Bolingbrook. That's a big commercial matter. That may cost the contractor $50,000. That's going to be a bigger case. The other part of it, from your perspective or the perspective of a lot of your clients, is if that plumber files a $5,000 lien against one of your client's properties, as an owner, they've got good leverage, because to file the lawsuit in Cook or Will County, the filing fee alone is going to be $400, $500, and they're going to have to pay an attorney a couple $1,000s to try to foreclose the lien in court with a lawsuit. So a lot of the time, it's not economical for a contractor to try to file and foreclose a $5,000 plumbing lien against an owner on a rehab job.
But it would be fair to say that the cost for these lawsuits are $5,000 for a small lawsuit and up. I mean, your $350,000 case, that could be $40,000 or $50,000 in attorney fees.
That's right.
Very, very easily. So the key component that I'm trying to stress here is that ounce of prevention is worth a pound of cure. I mean, Scott, heading up my litigation group, I like to joke, and Scott likes to tease me. I don't necessarily live in this palatial 8,000 square foot house that I grace my family with because of preventative medicine. Where attorneys really make their money is when our clients don't follow our advice and then they need to use us for that heart surgery. So I want to prevent people from making that mistake, because we've got plenty of big clients that can afford us. And I want those of us who are just regular Joe average investors who are trying to, build a small portfolio of properties to avoid just one mistake, which can eliminate all of the profit that you make in 1 year. Brian, any parting thoughts before we turn this over to Hugo? And then while Brian's speaking, again, guys, if you want to use the chat application on the side, for any of you who have any questions, feel free to just list those out in the chat box and we'll try to answer those. After today, we don't charge for questions, only answers. So if you want some free answers, go ahead and ask those this evening. Brian?
Gary, I think you covered it really well. I agree with what you say. The big being thorough up front, and I know it's hard, and I know in my own, I'm very thorough in my practice. I know in my personal life, I take shortcuts, I let things slip, and I always regret it. So when you're hiring people to do work, when you're putting together leases, be thorough, outline these things, prepare as though you have a problem down the road. And I agree with your little phrase there, an ounce of prevention is worth a pound of cure. So,
guys, just a little extra bonus material for you tonight. An update on the Illinois Eviction Moratorium. I'm just going to spend a second on that. The Center for Disease Control issued a federal regulation that's going to be published on September 5th. And the Center for Disease Control is going to, through a proclamation that's published under the Federal Register, state that if a tenant files a specific legal document and serves that upon the landlord, that says that they can't afford rent. There is now the eviction moratorium has been extended until December 31st of 2020. So that actually supersedes all state laws. That's now national. So absent emergency situations, which would be like, you know, somebody got shot, drug dealing, domestic violence, things of that nature, not paying, not unfortunately you having to file foreclosure because your tenant's not paying you rent, even though to me that's an emergency. That now seems to be the law of the land, where we're not going to be able to file evictions until December 31st. So that's a little bit of a bad news for landlords. We did get a couple of questions. Cherie, we're not licensed in Florida, but Hugo is going to put up my information on how to contact me. I'm happy to refer you. We do have colleagues in Florida that I can connect you with a good person down there. Dr. Ali, Dr. Ali, and I'm going to, Scott, put your microphone on. This is a question for you.
Right.
Dr. Ali, who is an extremely good friend of mine, his son is an Eagle Scout. I'm an Eagle Scout. And actually, Scott, you may know Dr. Ali. He was the chief psychologist for Will County for the court down there. But at any rate, Dr. Ali is asking, I hope that wasn't violating confidences, Doc. Does the mechanic's lien have priority over a lender's lien? That's a great question. And Dr. Ali's a lender, so it's obviously something near and dear to his heart.
The general answer to that is yes. The political situation in Illinois is such that the Illinois Supreme Court, favoring a lot of the union contractors, has placed the contractor ahead of the lender to the extent that the contractor enhances the value of the property. That's called the Doctrine of Enhancement, and there's a lot of detail to that. But if I was a lender, lenders need to watch and be very careful with their owners, with the people they lend to, because to give you a rough answer, very generally, the lien, mechanic's lien, will take priority over the mortgage loan, yes.
And Scott, he had a secondary question, which is, are there any protective measures or recourses that a private money lender can take to try to counteract that?
Well, the private money lender is an interested party, and the private money lender can be aggressive through the owner and kind of concurrent with the owner in demanding a contractor's sworn statement from a general contractor, which gives a price of the job, and it also lists all the subcontractors who are going to be doing work on the job. And the lender can get in there and be very aggressive and demand with the owner that the general contractor supply sworn statements, lien waivers, lien releases, and things of that nature. So the lender has every right as an interested party to be just as interested in that property as the owner is under the Mechanic's Lien Act.
Thank you so much. Thank you so much, Gary. I appreciate it.
Oh, thank you, Doc. Scott, I want to follow up on that for a second, because I'm not sure, sometimes I bloviate on things and I wonder if what I'm saying is true. I was suggesting at the beginning that both owners and lenders really almost require that we go through a title company escrow where they're collecting all of the lien waivers, and then that was a way to virtually insulate themselves from any liability. I know that we represent a lot of hard money lenders, and all of our hard money lenders, we require construction draws through a title company, but there's there's a lot of people listening that are part of several groups where everybody's loaning money back and forth, and we've got hodgepodge loan documents, and there's no construction escrows. And if a owner is required to pay a general contractor doesn't collect subs, and then there's subsequent subcontractor liens for $40,000, and the owner ultimately gets upside down, there's a tremendous amount of exposure for these private money lenders, right?
That is true, and I heard what you said at the beginning. The smartest thing is to use a title company with a construction escrow. You're absolutely right on that. That alleviates a lot of problem, and it kind of puts the title company on the hook if they make the mistake. But if people don't use title companies and they don't get the proper sworn statements and the proper subcontractor waivers and releases, you're exactly right. They can get into some bad situations. And if the owner doesn't get a sworn statement from a general contractor, the owner sometimes has to pay twice, and they can become very much upside down on these deals.
And you know, what's interesting about that is, again, the cost of these construction escrows with the title companies. I mean, literally, I think it's like they charge like a couple $100 a draw. Now, we have negotiated rates with the title company. If you call them directly, you're not going to be able to, you know, get those same rates, but we can pass those along to our customers to provide people with those very, very low rates. And this is a win-win. It's actually a win all the way around if people are honest and ethical, because the general or the owner and the lender have identical interests to ensure that the general contractor has paid their subs. And the general contractor actually has an interest in making sure that all those waivers are submitted, because if a subcontractor submits a final waiver of lien saying they're paid in full, that avoids all of the nonsense of the lien saying that, you know, now I'm owed an extra $2,000 because they've submitted their final lien waiver. So for me tonight, that's the one big takeaway. If you could do one thing such that everything else in your business would become easier and unnecessary to mitigate your risk and maximize your return, so that you can create that life worth living, that legacy worth leaving, and that business worth owning, it would be to do the construction draws through a title company and get your contracts in order. That's what we're here for, to give people a hand up. We're not here to ask for a handout. My why is helping others. So I appreciate everybody joining us tonight. I'm always available. I love Hugo. The ChicagoDealVault product is a magnificent product. For those of you who have not used it or not signed up, I encourage you to. It is literally the best product for off-market properties right now. It is a product that doesn't exist anywhere else out there in the market. And right now at this time, with interest rates being so low and inventory being so tight, I really encourage everybody to sign up for ChicagoDealVault. That's how a lot of my successful investors are finding their properties. So Hugo, thanks so much for having me.
Oh, thank you very much. I mean, the presentation, Scott, Brian, Gary, was mind-blowing. In fact, this is the first type of this kind of event that we've ever had, including Chicago RIA. So thank you very much. Gary thought about this important topic that is never brought up anywhere in the RIA. So thank you, Gary. That was very innovative and super important. And thank you for taking the time this evening and bringing your team for this webinar. I really appreciate it. It was just incredible. So friends, we want to give you a special offer. We're going to give you a free ticket to the 3-day event coming up for Chicago RIA on October 23rd through the 25th. On top of that, you're going to get a free 30-day trial of ChicagoDealVault. We posted Gary's contact information on the chat, and we also have it on the portal. I'm gonna.
Hugo, we can't hear you.
Thank you, Phil. So, friends, we're going to give you a free 30-day ticket for the upcoming 3-day event organized by Chicago RIA, Andrew Holmes, Rahul Vishal, and on top of that, free 30-day trial to ChicagoDealVault. All you need to do is fill out this form that I'm going to post on the chat and type in for the promo code Gary. Okay, so promo code will be Gary. So the package, select special ChicagoDealVault. Can you please post these notes? Absolutely perfect. Awesome. So those are the links, instructions for you to get a 30-day free trial. And on top of that, we're going to include a free ticket to the 3-day event organized by Chicago RIA. So again, thank you everyone for joining tonight. We're going to send you the replay first thing in the morning. And again, Gary, Scott, Brian, thanks a lot for your support. I appreciate your time.